ICSI, being a national professional body, has been associated with the Companies Act ever since the 1974, when for the first time the Act provided for the employment of company secretaries for companies having a paid up capital of 25 lakhs or more. Subsequently, in 1988, to be precise 15th June, the Companies Act was amended to provide for the certification of annual return by a concept of practicing company secretaries, and eventually on 13th December 2000, the concept of compliance certificate emerged in the Companies Act. In the new Companies Act 2013, the company secretary has emerged or is seeking to emerge from being a company secretary to a corporate governance professional. The Act, if I may say so, is contemporary, as it contains some of the most modern provisions of the Act elsewhere in the world. It is transformative in the sense that it ensures that every stakeholder who is associated with the corporate sector has been made to think, act and perform far differently from what they were doing earlier. It is also aspirational in the sense that many new corporations who are going to be formed in the years to come will have role models on whom they will build upon. So, as far as this Companies Act is concerned, ICSI has been given a phenomenal presence, not only in terms of those who are in employment, not only in terms of those who are in practice, but also for the first time the concept of secretarial standards has been recognized. I must also make a mention here about the concept of secretarial audit, which is also quite unique to the Act and also to this country, because across the globe there are about 70,000 company secretaries and India has 33,000 amongst them. And in this, it's quite befitting that India has chosen to take the lead as far as mandatorily requiring the secretarial audit from corporates. In fact, the rules as they have been brought out prescribe unambiguously that it is the company secretary who has to assist the board, advise the board on various issues, including those nuances and niceties of corporate governance across the board and across the company. So he has to assume the role of a custodian of good corporate governance, and perhaps over a period of time lead the board, advise the board in ensuring that the board confers on him or anoints him to be the conscience keeper of the board and the company. This video series which we have done has been the culmination of a series of thought process whereby we wanted to reach out to as many people as we can, including various stakeholders, more particularly our members, the regulators, students, who can get a bird's eye view of the concepts of this Act in a far clear and in a far concise manner. I am sure that the series of videos which have been produced by ICSI will become a visual experience of learning. It's not necessarily experiential learning, and on behalf of ICSI, I wish each one of you happy viewing. Thank you.
Hello and welcome to this episode on the philosophy, thrust and principles underlying the Companies Act 2013. To discuss these issues on this episode, we have with us Mr. P.K. Malhotra, who is the Secretary, Legislative Department, Ministry of Law and Justice. And on the phone line, we have with us Mr. Arvind Datta, Senior Counsel, Madras High Court. May I start the discussion, Mr. Malhotra, by asking whether you'd like to talk about any of the key features of the Act which underline the core principles and the thrust of the philosophy of this Act.
Well, before I come to the provision of the present enactment, let me dwell a little bit on the issue that why this Act was 1956 Act was replaced by the new enactment.
Right.
You see, when the 1956 Act was enacted, at that time there were only few thousands companies which were registered in the country. During the last 56 onward, we are now in 2013, lot of development, economic development has taken place. There is a change in the economic scenario, international and national. The Indian economy has opened up since 90s, and international business opportunities have increased. Economy is becoming more complex and dynamic, and it was felt by the government that probably the provision of the 1956 Act are not sufficient to meet the present day requirement. Therefore, a committee was constituted with the name J.J. Irani Committee, which dwelt onto this issue, and based on the recommendation of the Irani Committee, a report was given, and in 2008 a bill was introduced.
Right.
This bill was further refined because it was examined by the departmental related parliamentary standing committee, and a fresh bill was introduced. In between, certain amendments are also carried out in the Companies Act in the year 1992 and thereafter in 2001, but they became subject matter of challenge before the court, and that litigation ended in 2010 only. At that time, keeping in view whatever recommendations have been made by the committee, the Parliamentary Standing Committee, the Irani Committee, and the Constitution Bench judgment of 2010, government brought this new law. And the guiding principle of this new legislation, which is passed in 2013, is some of the features which I would like to highlight are the enhanced accountability on the part of the company, and this enhanced accountability include tenure and liability of independent directors, corporate social responsibility, more of corporate social responsibility to be discharged by the companies, and for that there is a provision for constituting committee. There is a vigil mechanism to encourage ethical corporate behavior, and audit and accountability and rotation of auditors have been made compulsory. National Financial Reporting Authority to ensure compliance of accounting and auditing standards have been provision has been made. Then merger and acquisition have been further facilitated, and special thrust has been given on investor protection and easy dispute resolution. These are some of the key features which have been built into this new legislation.
Right. Mr. Datar, would you like to elaborate on any of these?
Yes, I must say that Mr. Malhotra has succinctly summarized the important changes. In fact, if you notice, our Act came in 1956, and which was based on the English Companies Act of 1948. And thereafter, England has had two Companies Act, and we had not replaced the Act to take note of various changes. So now this 2013 Act has come, replacing the Act. And incidentally, one thing I'd like to mention is it's exactly 100 years since the first Companies Act 1913 was enacted. Yeah, so that's also a landmark here in that sense. And there are definitely welcome changes which we'll discuss as we go along. And I find that the basic philosophy, if I may say so, of the Act is to bring it more in tune with international provisions. Secondly, I find that they have made very stringent provisions of penalty. So the government has indicated that there will be very little tolerance for violations of the provisions. And I find that a lot of emphasis has been given to protect the interests of depositors and shareholders. So in that sense, there have been many changes that have been made in the new Act.
So Malhotra, you mentioned about investor protection or broader governance and higher standards in terms of stakeholder role, etc. Can we talk a little bit about uh, the board structure or the audit process? You mentioned the whistleblower system and the need for boards to be more cognizant of interests of all stakeholders. Would you like to elaborate on any of these in specific context of the broad principle of the Act?
You see, on this investor protection front, I think we have traveled a lot in the new Act, and disclosure norms which are to be followed by the company, they have been elaborated and discussed in greater detail in the new Act. Then whenever the fines are collected after the tribunal or the registrar or the court has imposed any fine, the fines can be applied for payment of the cost of the proceedings to the person who has brought the litigation before the court. And another important feature of this bill with regard to investor protection, which I find, is that individual investors sometimes find it really very difficult to approach the tribunal, and therefore a special provision has been made in the Act for class action. So either the association of investors or a number, say 100 members of a company, can file a class action against a company in case they find that the action taken by the company is prejudicial to the interest of the company or its investor. They can approach the tribunal, they can approach the court, and cognizance of the offences being committed by the company under the Act, it can be taken care of by the on a complaint made by the registrar, and even by the shareholders can approach the court and make a complaint for taking cognizance of the offences that may be committed by the company.
Right. So you'd feel that the access to the justice delivery system,
Yes,
of investors is superior now.
definitely. I mean, there is a lot of improvement now. Earlier there used to be handicap, but now I think it is more the Act is more acting as a facilitator,
Right.
and allowing for investor to approach the courts or the justice redressal forum. In addition, what I find is that in the new system, at least you have only one forum which you have to approach. Earlier, under the Companies Act, there used to be 3 different forums. For winding up process, you have to go to the High Court, and for your day-to-day work, you have to go to the registrar. For your if a company is to be declared a sick company, you have to approach SICA, or for other matters against the order of the registrar, you have to go to the Company Law Board. Now at least there is a one forum, that is the National Company Law Tribunal, which will take care of all these aspects, and in case any person is aggrieved by the decision of the National Company Law Tribunal, there is a provision for filing an appeal to the appellate tribunal. So I think the system has been more put in place, and it has been more systematized, and I think it is more user friendly now.
So in some sense, this also enables these sort of disputes to be taken off the civil court system, which is clogged with a lot of backlog.
Yeah, surely, because the tribunals will be a specialized agency which will be having one judicial member and one technical member. It is expected that the dispute redressal mechanism will be acting much faster, and you will be getting a better justice because you have a judicial member, you have a technical member on the bench, and process will be much faster and the justice will be much quicker.
Right. Mr. Datta, can I bring you in on this? Would you like to comment about the constitution of the tribunal as a alternative forum for the civil court system, and also touch upon class action and provisions for oppression mismanagement as to how these empower greater investor protection?
Yes. Now, we'll have to just go into a brief history. You see, before the Company Law Board came in 1988 and started functioning in 1991, you had basically a certain number of sections given to the company code, which was a part of the High Court in all the states, and winding up, reduction of capital, and so on was with the company code. And then after the Sachar committee, we had the Company Law Board, which started dealing with operation mismanagement, transfer of shares, and a few provisions. Now, what was not dealt with by the winding up court and what was not being dealt with by the company law board became a residuary matter which was dealt with by the ordinary civil courts. So, for example, if there is some dispute regarding an annual general meeting, you could straight away go to the civil court. And as Mr. Malhotra puts it, you had 3 different fora which would decide various disputes. And now the intention is to bring everything under one umbrella, and there will be no question of going back to the civil court for any kind of redressal. So everything will be confined here. Secondly, on operation mismanagement, if you see these sections, there's a lot of housekeeping that has been done. They have reduced the number of sections. They have combined 397, 398 into one particular provision. And in my opinion, made it simpler in that sense to combine both in that particular section. Similarly, interim relief is made part of the main section itself. So there is a good amount of simplification as far as these 2 important areas of litigation are concerned. Now, coming to class action, the provisions, it is indeed a welcome provision because the people who had no voice, I mean, unless you went under a separate provision under section 92 of the Civil Procedure Code, which is very cumbersome. Now, here is a statutorily prescribed model for the minorities to have their grievances redressed through the class action procedure. And what is important in class action is, unlike operation which was only could be agitated by members, here for the first time even depositors or any class of depositors can come and take a class action and have their grievances redressed before the tribunal. So this is really going to be an interesting provision, and as the years go by we'll have to see how this actually pans out in practice. But for the first time there's a provision for class action which was not there earlier at all. So it's a welcome move, and we'll have to really look forward to see it being worked effectively. And now the other point is, it sort of gives a warning to the management that they can't ride roughshod over the rights of minority depositors, because they will be answerable to the company tribunal in the event depositors take up their matters.
More important points which I would like to make on this particular issue is that one is the power of compounding of offences which have been given to the registrar as well as to the courts, and the power of contempt given to the tribunal.
Right.
I think these are very, very welcome measures, because this will enforce a discipline among the companies, and companies will have deterrent effect of the company, and they will be complying with these statutory provisions. In addition, with regard to investigation of frauds, statutory provision has been given to the serious fraud investigating organization, and the fraud itself has been defined, and for prosecution under this Companies Act, I think now a special provision has been made for constitution of special courts which will be specifically dealing with these cases, and punishment will be much quicker and much faster in addition to civil penalties.
Right. So for the benefit of viewers of this video, could you dwell a little more on the power of contempt that has been given to the tribunal and how this is going to impact the principle?
You see, going by the existing principle of the as enshrined in the Constitution, only the courts of record, that is the Supreme Court and the High Court, have these powers. But there have been precedent where power of contempt have been given to some of the tribunals, like the Armed Forces Tribunal has this power, like the Administrative Tribunal has got this power. On the same analogy, because these National Company Law Tribunal will be dealing with the economic matters, and in economic matters it is always necessary that expediency should be shown, that so that the economic growth doesn't come to a standstill because of long litigation between the companies. Therefore, I think this power, giving contempt power to the courts, to the tribunals, is a welcome move.
Right.
And I don't see anything wrong in this, because there are precedents available for about 10 to 15 years. There are few tribunals which are almost discharging power equivalent to the High Court. They have been given this power.
Right. Therefore, to drill into that a little more, if one were to disobey an order of the tribunal,
Yes.
they would be committing a contempt of court
Yes.
qua that tribunal.
Yeah, definitely, and it is not necessary, because in the normal courts, if contempt is committed of an order passed by the tribunal, tribunal has to make a reference to the High Court, and
Right.
then High Court takes a cognizance of it. But now there is no need to make a reference to the High
Right.
Court. The cognizance can be taken by the tribunal, and the punishment can
Of
be
its
given
own, suo
of its
moto,
own.
or
Yeah.
any parties can approach the tribunal.
That's right.
Saying you ruled in this manner, but the party is disobeying it.
That's right.
So, Datar, can I come to you on a related point? The role of the tribunal, the power of the tribunal, it spreads across all these areas of class action, the oppression mismanagement. Can you talk a little bit also about schemes of arrangement and what has happened to the law here and how it is going to impact?
You want me to speak on the law relating to mergers and acquisitions?
Yeah, schemes of arrangement, compromise, mergers,
Yes.
acquisitions,
Yes,
and
yes.
what sort of reform has taken place in that area?
Yes. One thing, if I may just mention about the punishment for contempt, the idea is that one of the ways in which the court acquires some kind of power of ensuring compliance with orders is the power of contempt, and that has been given to the tribunal now. Mr. Malhotra mentioned about other examples. The only point which will have to be clarified is that if the tribunal is going to, because the Contempt of Courts Act under section 12, you can sentence a person to imprisonment for up to 3 months and levy fine. Now the only thing which will have to be clarified is whether a tribunal, which is not a court, can sentence a man to imprisonment. That will have to be clarified, because as a general rule, the power to punish by way of imprisonment, by way of incarceration, is the preserve of courts. So I do not know how, because you have made all the provisions of the 1971 Contempt of Courts Act applicable to the tribunal. So much so that what the Advocate General has to refer can be referred to by one of the law officers who can decide this question of contempt. So this imprisonment point will have to be watched with caution. That's the point. Coming to the issue of mergers and acquisitions, I must say that there's a lot of positive provisions in the context of mergers and acquisitions. In particular, what I like is they have simplified this mergers and acquisition of small companies. As you know, and for holding and subsidiary companies. As you know, earlier we had to go to the court, and whether it's a merger of a 100 crore company or a merger of a small company, the entire procedure had to be followed. And some courts would dispense with advertisement, others would not, and it led to a lot of unnecessary delay. But now this segregation of small companies and holding and subsidiary is a great relief, and the tribunal can dispose of these cases on a at a much faster pace. That's what I personally feel. Then, as far as mergers are concerned, there are very many dramatic changes which we can't discuss in this short time. But what I find important is that there is a requirement of valuation. Earlier there was a controversy whether the valuation report also has to be enclosed. Now they say they made it very clear that you must disclose the valuation report also to the shareholders and the creditors. And the meeting of creditors has become mandatory. Earlier, the courts had the power to dispense with meetings, and which they did. Normally, they would dispense meeting of unsecured creditors.
Right.
But now they made it mandatory. But that also, I may say so, will lead to one small point, because an unsecured creditor can include anybody from 100 rupees to 1 crore.
Right.
So if you have to get the consent of all the unsecured creditors, that has led to practical problems in the High Court. So unless there is a possibility of saying that unsecured creditors above a certain percentage, that may help. But right now, you have to get the consent of creditors also who are going to be affected by the merger. That's made a mandatory provision. And they have also, it's necessary now to send this, what you call, the board resolution can be done by video conferencing. That's an interesting provision. And one thing, Somashekar, earlier we had to file this merger at the end of the proceedings. Now you're supposed to file it immediately with the ROC. So the entire law of merger and acquisition has gone a major overhaul,
Right.
which will have to be, which is over, by and large, extremely welcome.
Right. So Malhotra, can I bring you in on another counterbalancing measure?
Yes.
Akin to this provisions on operation mismanagement.
Yes.
Now the objection to a merger
Yes.
or a scheme of arrangement
Yes.
cannot be taken by anybody owning even one share or two shares. There is a threshold of ownership, say 10%,
Yes.
without which you can't raise a valid objection.
Yes. And 5% for creditors, I think.
Right. So that's you see that as a valid counterbalancing measure as well, because just as we spoke in the earlier part about investor protection being one of the core focus areas,
Yes.
I think this also balances and lets frivolous objections not get entertained.
Yes, in one sense, yes, because I've seen in my experience that where the court has called for meetings of unsecured creditors, they use it as a weapon to delay the merger and try to use it as an instrument of getting back their money or arm twisting the company. So by putting a threshold limit of 5%, you don't have a minor group who have hardly 2-3% of the outstandings coming to court and holding the entire proceedings to ransom. The only one point is that earlier the law was that if it's an illegality, suppose there's a merger or an acquisition and it was contrary to law, then even one shareholder could get up and object. He need not have that 5%, 10%. Even if 99% of the members in a meeting approved the merger, one person could point out an illegality and get it done. Now that won't happen unless 10% members object and 5% creditors object. The others can't have no locus standi to come to the tribunal and oppose the merger. So they impose a threshold limit. There is a minus side to this because you may have a situation where a 2% shareholder may have a valid objection which he can't now raise.
Right.
I think overall it's better because we can completely eliminate frivolous objections.
Right.
I think Mr. Datar has very briefly given the whole scope of this chapter 15 of the restructuring and arrangement which is dealt with in chapter 15, and tribunal has been empowered to sanction arrangement for restructuring so that it can provide for conversion of preference share into equity shares or protection of any class of creditors or pass appropriate order concerning dissenting shareholders. All these procedures have been simplified and it has been the procedure which was earlier considered to be cumbersome has now become more simple, and now a single forum for approval of merger and acquisition is available under the new act.
Right. Can I ask a related question? I mean, we spoke about stringency of penalties and that penalties have been enhanced, etc.
Yes.
Do you see that the Act is, while it has the usual process for setting the criminal justice system into motion, either by the registrar or any of the designated authorities, including SEBI, a proviso to the provision suggests that it does not preclude an employer, for example, setting the criminal justice system in motion
Yes.
against an employee. So do you see this as perhaps a process whereby even a private citizen can truly set the justice system in motion for a criminal prosecution of a breach of the Act?
I think this is a very valid question and maybe it will be very difficult to answer the way you are putting it. But only thing I can say is that the stringent penalty and the prosecution probably acts as a deterrent.
Right.
So far as the companies are concerned, that they will be having a deterrent effect of the company and they will be more prone to the compliance than to the violation. But that approach which normally some of the Indian companies apply, that chalta hai,
Right.
that approach will go
Right.
with the deterrence. But simply because deterrent effect penalty, they do have deterrent effect, but more important is quick action and time bound conclusion of the proceedings. If the courts are delaying the matter, then howsoever deterrent the penalties may be, that may not have the effect. The example is before us. I mean, I'm going out of the subject, but this may be relevant with regard to the deterrence of the penalties and the stringent penalties which are being provided in the law. We recently have seen that 16th December incident in Delhi led to passing of a criminal law amendment bill, passing giving stringent punishment with regard to rape laws. But what has happened thereafter? Had the really that stringent penalty brought down these instances have increased thereafter. Rather, maybe we can say reporting has repeat. So similarly, the deterrent penalty will definitely have the impact, but that is not the solution. Solution is proper implementation of the law and quick justice. And in that direction, I think the steps taken in the new act will be of some help.
Mr. Datar, can I bring you in on the same issue?
Yes, yes. You see, as far as this special courts are concerned, which is in chapter 28 of the new act,
yes.
Like in the past, the offences are non-cognizable. That is to say,
yes.
You require a complaint before the law can be set in motion. And if you see 439 subsection 2, I'm sorry, I'm getting technical, but you'll find that the offence can be, the court can take cognizance of the offence on the complaint of a registrar, of course, and of a shareholder of a company, or any other person authorized by the central government. So a single shareholder can launch a complaint in the event of any offence being committed under this act. One important thing is there is no power for a creditor or a depositor to set the criminal law in motion. That's an important point. Secondly, like the past, the compounding provisions continue in 441. And from what I see, if you read the main section, you see today what happens is in most states, one or two courts are designated as economic offences court, which try offences under Companies Act, Income Tax Act, and Central Tax Act, and so on. So I think that the central government may continue the same procedure. Instead of establishing new courts afresh, they may perhaps designate the same courts to continue as the special courts. But only one thing I may mention, now that the Act has shown, has increased the number of fine, the quantum of fine has made the Act quite stringent, and they want to show that they mean business. I think there must be more prosecutions of violations, because what I generally find as a lawyer is most of the prosecutions are only for very small matters which inevitably get compounded. And serious matters like falsification of accounts and so on, there are hardly any prosecutions. So now that it is coming before the special courts and the new streamlined procedure is there, as Mr. Malhotra says, unless you show that the Act is going to be implemented with an iron hand, these provisions really will not make a difference, as he mentioned, unless you show the results on the ground. Yes.
Otherwise, we usually have a culture of being over-regulated and under-enforced. So you feel we should step up the enforcement measures as well?
I think in addition to that, I would like to refer to one more provision, that is with regard to the provision for mediation and conciliation panel, for which the provision has been made in the new Act. I think if any agreed person whose matter is pending before the tribunal or before the court, he can make a request for reference of his dispute to the mediation and conciliation panel. Probably this type of making a statutory provision in the law for mediation and conciliation will help in reducing litigation and a quick disposal of the disputes.
Yes.
Only one thing I would like Mr. Malhotra to clarify. I had a doubt when I saw this mediation and conciliation panel. Now I want to know whether they are going to be some kind of the government is going to have some training program for mediators who will be trained mediators on this particular panel, and whether you're going to have a panel for every bench of the tribunal, or how is it going to come out, has to be really watched. And the other thing which I have my doubt, I wanted to know was, if there is a mediation between two parties, say in an operation mismanagement, yes, there is a mediation panel here. Under the Legal Services Act, even today, those two parties can have their dispute referred to the High Court Mediation Center or the nearest mediation center. Now, this is going to be a center over and above that. 2 points. One, is there going to be some training scheme for mediators? Are there going to be dedicated mediators in company law? Like we have mediators in family law and labor law and so on. That's one thing. And secondly, does the Act contemplate mediation of a dispute between the government, central government, and the company? Is that possible?
Yes, to the best of my understanding of the provisions which I have read it, probably government is going to frame certain rules in this regard, and while framing the rule, probably there will be a panel of mediators and conciliator. So far as their training is concerned, I think as on today there is no scheme, but obviously if they want to have a panel, obviously they have to go for a training course for the mediators and conciliators also, and some of the institutions in the country are already doing this job. For example, I can tell you that International Center for Alternate Dispute Resolution, which is headquartered at Delhi, is already conducting regular mediation and conciliation programs, and they are training the trainers. And I think probably their services can also be utilized and they can be put in the panel, and this probably will be a more effective method of settlement of grievances as compared to the normal channel of courts or the tribunals.
Absolutely. In fact, I would suggest, if I may offer a suggestion,
Yes.
we already have, like you mentioned Delhi. Delhi High Court has got a trained mediation center. You rightly mentioned the ADR center, International ADR Center.
Yes.
They already have a body of trained mediators who are doing excellent work.
Yes.
I thought those who are already trained and have got the necessary certificate from the for undergoing that 40 hours of training or what training as prescribed in various courts, they can automatically be made on the panel if they have got some experience in company law. So they may not be need for a fresh training. But the point that to be clarified is, for example, if there are some minor disputes between the ROC and the company, whether that can go for mediation. That also may settle the matter. We need not go to court and litigate on those points. I mean, go to the National Tribunal and.
I think if there are certain grey area, Mr. Datar, under the Act itself, the central government has been given power to exercise its power and remove difficulties. And fortunately, in this Act, that power to remove difficulty, that clause is available for a period of 5 years. I think 5 years is too good a period during which all these, in case certain difficulties are coming in its implementation, or there are certain gaps which are to be filled, like the one which you have pointed out. Probably while making rules, that power can be used and all those gaps can be filled in while exercising that power.
Exactly.
Right.
Like
Speaking,
use the word of Lord Denning, we can iron out the creases.
That's right. Then speaking about the purely from an ICSI perspective,
Yes.
I hope the mediation conciliation process
Yes.
enables more practicing company secretaries to build capacity and play that role.
Yeah, surely. Why not? Because they are expert in the subject. They know the company law well, and ultimate aim is to render justice to the companies as well as to the investor. And I think there can't be better person than the three organizations like Chartered Accountant Institute, Company Secretary Institute, ICWA. There can't be better person than these
And
persons.
of course the bar council.
No,
Of course, that goes without saying.
Because I never thought of it. I think company secretaries also can undergo the standard training.
Yes.
And because they definitely know much more company law than most lawyers. That's a fact. I mean, because they're doing company law day in and day out.
Yes.
And I think they will be also well equipped to handle these mediation cases.
Right. So before we wrap up, may I request each of you to summarize and also cover any other aspects that we may have left out so far, particularly from the perspective of the central principles and philosophy behind the new Act.
Well, I think the procedures have been more simplified, and I can again, maybe I can repeat it. The broad coverage of the Act can be that now the Act recognizes one person company also with the simple compliance regime, and then you have a provision whereby you must have a women director also, that is to give proper representation to the women in the company. And company processes now can be carried through electronic mode, that is e-governance, which Mr. Datar has mentioned, and I think that should be implemented more speedily. And speedy incorporation process, the provision has been made, and the duties of liabilities of the independent director in a separate schedule, it has been mentioned, and they have been given more responsibilities. And another point which I would like to make here is that I think the directors and the company employees, they have been specifically prohibited from forward dealings.
Right.
And of course, we have discussed about simplifying the procedure with regard to merger and acquisition. And one more area which I probably didn't mention, and one of the important ingredient is with regard to the investor education and protection fund which has been created, and the claims which are lying with the companies for more than 7 years and pertain to the investor, they will not remain with the company. They can be transferred to the investor and education protection fund.
And even the securities go to the fund.
They go to the security fund, and probably they can be better utilized. And another important feature, of course, on which Mr. Datar and myself has also dealt upon is the class action, which is a novel idea in the new Act, and I think this provision will definitely make our corporate governance much better as compared to what it was under the 1956 Act.
Right. Mr. Datar?
See, I find the most important, if I may say so, dramatic change is a large amount of delegated legislation. You see, the idea is that in my opinion, will give certain amount of flexibility. There's some change required, you don't have to keep on going to Parliament. So you find that in this Act, you've got 470 sections, whereas in the early Act, you had about 600 odd sections. And I find that in as many as 340 odd places, you have rules as will be prescribed. So this is like the old Central Excise Act model. You see, if you take the 1944 Act, the Act was just 40 sections, and we had about 230 odd rules which administered different parts of the Act, you see, on licensing and so on and so forth. So like that, I think we have made the shift where the Act gives a skeletal frame, and the flesh and blood, etc., is filled up by the rules, which may require changes from time to time. So that's a very important change. It's very unusual because you have an Act with also a large body of rules. And I think they may just have one comprehensive company code, company rules, rather than having multiple rules. So we'll have to see how they are going on that point. That's a very important change. And keeping in mind this is one legislation which covers the entire corporate sector, which covers the lifeblood of the economy. So the rules also will have great importance as they come, number one. Number two, as I said, they have rightly increased the fines. You see, the earlier Act had fines of 50 rupees and 100 rupees, which made no sense keeping in mind the value of the rupee and the changing time. So these large fines again is an important change. The third thing which must be noticed, Mr. Malhotra has talked of investor protection fund, I won't repeat. This principle of disgorgement of gains, this is a very unusual thing and very welcome. Because traditionally in English law, you have damages where if I suffer loss, I get compensation by way of damages. So I only get what I have lost. But in disgorgement, which is a very key factor of restitution, the person who gets a wrongful gain cannot keep it. He has to pay it back. And this disgorgement principle was only contained in the Trust Act, which I am very glad to know has been brought into the Companies Act. So a person cannot exploit his ill-gotten gains. He must know and he must realize that there could come a time where he is asked to disgorge, that is, pay the entire gains back into the protector fund for being applied as per the Act. So this disgorgement, these rules and this investor protection are very important changes. I also noticed there are also a lot of IT related tools like video conferencing being permitted, and so many simplifications have been made which take advantage of the development of information technology, which will also save time. That I think is very important. That as we know, this is a new baby, and we just have to wait and watch and hope that it grows into a very strong and powerful enactment to promote better corporate governance.
Right.
I am in agreement with what Mr. Datar has said with regard to regulating the procedure through subordinate legislation, and being head of the legislative department in the government of India, I also have certain personal views also. Of course, I am not expressing government view here, I am expressing my personal view. I think legislation, the parliament today, because the legislations have become too technical, governance has become too technical. So legislature should only give the skeleton, they must lay down the basic principles, essential legislative function they must discharge, and rest of the thing should be left to the expert body so that it can be regulated through rules. And in that direction, I think this is the steps which have been taken in the Companies Act is a welcome step.
Right. That's all we have time for on this episode. Thank you very much, Mr. Malhotra. Thank you, Mr. Datar. The idea.
I think we must thank you so much, Lekha, for asking
all
the important questions.
Thank you.
Thank you.
Thank you. For the viewers, the idea behind this video is to give you an overview of the essential principles and philosophy behind the Act. We encourage you to read the provisions and acquaint yourselves. Thank you very much for being with us.